much. 各位大家好. So yesterday, I'm going to go back a few slides. Yesterday we talked about the general rules of evidence disclosure in the United States, and we talked about the different sources of the prosecution's obligation to disclose evidence. So Rule 16 of the Federal Rules of Criminal Procedure is the general rule laying out the prosecution's obligations. There's also, of course, the U.S. Constitution, the Due Process Clause. We talked about the Brady versus Maryland case, which sets the standard for the prosecution's duty to disclose evidence favorable to the defense. And then Giglio versus United States, another U.S. Supreme Court case, which establishes the prosecution's obligations to disclose impeachment evidence to the defense. Today, I want to talk about the obligation to disclose prior statements of witnesses. And this, in the United States especially, is a very, very important aspect of evidence disclosure. So we'll talk about that, and I also want to discuss that and the general issues around evidence disclosure by discussing two cases. One is one of my cases. It was a sort of a murder-related case, and the other case is a very famous prosecution of a United States senator, and I look forward to discussing both of those with you. So, let's start with Jencks versus United States. This is the leading case related to disclosure of prior witness statements. Now, in 1957, you may be familiar with the history in the United States. During the 1950s, there was great concern about people becoming members, American citizens becoming members of the Communist Party. And so people were, anybody who was suspected of being associated with the Communist Party was closely watched by the government. And the Jencks case actually arose out of that historical situation. So what happened in Jencks was the defendant, Mr. Jencks, was convicted of making a false statement to the U.S. government claiming that he was not a member of the Communist Party. And during trial, the government presented two key witnesses. They were both Communist Party members who had been cooperating with the FBI, and they'd been attending Communist Party activities, and they were reporting to the FBI about these activities and the people participating in them. And at trial, they testified that they had made reports to the FBI about these activities at the time they were taking place. And the defense asked to see those reports, and the trial court said, no, you can't see those reports. So the case went up on appeal. It went all the way to the U.S. Supreme Court, and the U.S. Supreme Court said the trial court should have permitted those reports to be produced to the defense because they related to the matters that the witnesses had testified about. And the court's reason for this was, they said, these reports were important for impeaching the credibility of the witnesses, and those witnesses had admitted during trial, during cross-examination, that they couldn't remember what they had put in those reports at the time they wrote them. The trial took place 2 or 3 years after those reports had been written. These witnesses couldn't recall what they wrote, so the defense naturally wanted to see what was actually in the reports. And the Supreme Court, I think correctly, decided that it was very important for these reports to be produced because they were the only way the defense could impeach the credibility of these very important prosecution witnesses. And I want to quote a section from the opinion because I think it's very, very important language from the U.S. Supreme Court. The court said, because only the defense is adequately equipped to determine the effective use for purpose of discrediting the government's witness and thereby furthering the accused defense, the defense must initially be entitled to see them, to determine what use may be made of them. Justice requires no less. I think this statement it's really important, especially for the topic that we've been discussing the last 2 days. And it's very significant that the United States Supreme Court recognized back in 1957 that only the defense is adequately equipped to determine the effective use of this kind of information. It's interesting that this language from this 1957 U.S. Supreme Court case is very rarely cited today. It's not famous language, but it's there, and I think it's correct. So the Jencks case was decided in the middle of 1957, and within a few months, the United States Congress already got into action. And the U.S. Congress enacted what's now called the Jencks Act. And the Jencks Act says we are going to restrict disclosure of prior statements of government witnesses other than the defendant until after that witness has testified on direct examination during trial. So this means, for example, in the Jencks case, the defense would not have received those reports during pretrial evidence disclosure. The defense would have received those reports only after those witnesses testified during the government's case at trial. And then the procedure from this law is that after the witness testifies, the reports are produced to the defense, and the court takes a break so the defense can read the reports, and then the defense will come back and cross-examine the witnesses. Actually, I skipped a step. The real procedure is the reports are produced to the court first, and then the court decides if they should be produced to the defense entirely or just the part that relates to what the witness testified about. And then the court will decide which parts of those reports get produced to the defense, and then the defense takes a break, the court takes a break, the defense prepares and comes back and cross-examines. In 1979, over 20 years later, the Jencks Act was made into Rule 26.2 of the Federal Rules of Criminal Procedure. This rule expanded the Jencks Act to apply to prior statements of witnesses of either party, again, excluding the defendant. The defendant's prior statements don't need to be produced unless those statements were made to the government, in which case the government does need to produce them to the defense. And also, when this became part of Rule 26.2, it was made to apply not just to trials, but also to pretrial hearings. So let me just make one note about that. You heard that I previously practiced in Texas. So I've spent a lot of time in court in both Texas and New York City, and the procedures are very different in those two jurisdictions, even in federal court. So in Texas, sometimes the judges do grant the defendants probable cause hearings. Remember yesterday I mentioned if a case is started by criminal complaint, the defendant is entitled to a probable cause hearing. The government has to produce witnesses to testify and produce evidence that there's probable cause to believe the defendant committed the crime. In a probable cause hearing in Texas, after the government witness testified, we would always ask the court, pursuant to Rule 26.2, to have the government produce the prior statements of that witness related to the matters the witness testified about. And that was an extremely important opportunity for defense counsel at the very earliest stages of a case. Usually, this was the first day. I was with the federal public defender in Houston, and we would be told in the morning, you're going to be appointed to represent this defendant. You're going to show up in court at 10 o'clock or 2 o'clock. And sometimes on that same day, we would have the probable cause hearing, and we would have a chance to view those prior statements. In New York, for a number of reasons that we don't need to discuss, you never get a probable cause hearing. The government always goes to the grand jury and gets an indictment. So you never have this opportunity. But Rule 26.2 actually can be a very important and helpful rule for the defense, not just at trial, but also in pretrial hearings. But more importantly, the Jencks Act really significantly impairs the defendant's ability to prepare the defense. Okay? Most courts recognize that it's very impractical to interrupt the court proceedings after the direct examination of each witness so that the other party can prepare for cross-examination. It's not an efficient way to proceed in trial, and it's particularly harmful to juries, to jurors who are spending their time listening to these cases. If they keep getting interrupted for this, it's really not fair to them. So most courts do order the government to produce the prior statements before the witness testifies, and the idea is to give the defense a reasonable chance to prepare for cross-examination. But, again, every jurisdiction in the United States is different. And so in some jurisdictions, you get a lot of time to review the Jencks material, and in some, like New York, you get very little. And so very often the defendant has to make a decision about whether to plead or to go to trial without ever having seen the prior statements of witnesses, including the key government witnesses, and that in many cases is the most important evidence in the case. So in Manhattan, the federal courts typically allow the government to produce the prior statements of witnesses on the Friday before a trial starts on Monday. Okay, so that's, and by the way, the government usually makes this available at about 5 p.m. on Friday afternoon. So, so you have really about 2 days to review this material. And even in a very simple case, the disclosure of prior statements of witnesses so close to trial places the defendant at a tremendous disadvantage. But as I mentioned, in some cases, most of the evidence against a defendant comes from cooperating witnesses. And these cooperating witnesses, these are witnesses who have decided to help the government in exchange for leniency in their own cases. In many cases, these cooperating witnesses have been meeting with the government for weeks, months, or in some cases, years, okay, and providing information. And at every one of those meetings, there's at least one prosecutor and at least one case agent taking detailed notes. And I've represented cooperating witnesses as well as defendants in federal cases, and I can tell you those meetings Like I said, they can go on for months or years, and they can be several hours each, and there can be hundreds of pages of notes. And in some cases, you might have not only hundreds, but thousands of pages of prior witness statements. Now, when a witness has made so many statements to the government over time, the most important thing that a defense attorney can do is analyze those statements and see if the witness's story has changed over time, even a little bit. And so the pressure to make that kind of analysis in just a matter of hours, and often you're doing this for more than one witness, really undermines the right to cross-examine the witnesses against you. One of the rights that criminal defendants have under the U.S. Constitution is a right to cross-examine or to confront the witnesses against you. And if you have to do it under these circumstances, under this kind of pressure, it's a real problem and really undermines the fairness of the trial. And you'll recall yesterday that under the Brady case, the government has an obligation to disclose information that is favorable and material to the defense. And under Giglio, the government has an obligation to disclose evidence that might help impeach the credibility of the government's witnesses. But when that kind of evidence is part of a prior witness statement, the government's position is generally, we're not going to provide that until we provide the Jencks material because it's a prior witness statement. So they don't usually disclose it in advance. It's disclosed only when you get the rest of the Jencks material, whether that's 2 days or 2 weeks or before trial or after the witness has testified. So I want to give you a case example from my own practice, because I think this is a good example of some of the problems that can happen with a rule that permits such late disclosure of the prior witness statements. So I represented a man in New York who was charged with he was accused of hiring somebody else to murder somebody. The other person was named Jesus Rosa. Now, in this case, nobody was actually killed, but Mr. Rosa did walk into a building, point a gun at somebody, and demand that person's watch. The gun went off, and the victim was injured in the leg. So 2 people were charged, my client and one other person, a driver. Now, we knew from some of the charging documents that Rosa was the key witness in the case, and we also knew that Rosa was the only witness who could establish that the plan was to murder somebody as opposed to just stealing a watch. Okay, there were no other witnesses who could provide evidence of intent to plan a murder. It was only Rosa. We also knew that Rosa had a long criminal history. We knew he'd been cooperating for many months, possibly more than a year, with the government. And we knew he'd been interviewed by not only federal agents, but state police and a number of different law enforcement authorities. But except for some information in the search warrant affidavits that we did get, we spent well over a year defending the case without ever seeing a single report of Rosa's prior statements to the government. Now, both defendants maintained their innocence. They both planned to go to trial. And we asked to have the trials separated because we thought that their defenses were inconsistent with each other and we couldn't fairly go to trial together. So rare to get them separated, but we succeeded in this case. So the trials were separated, and to this day I don't know why, but the government chose to have the other defendant be tried first. So when that lawyer for the other defendant received, the hundreds of pages of Rosa's prior statements to the government, and he got them just 3 days before trial, he called me up and he said that he was going to request additional time to prepare for trial because he learned from those notes that Rosa had significant mental impairments that had not previously been disclosed to the defense. And specifically, what those notes revealed was that Rosa had admitted during his meetings with the government that he had all of his life been a paranoid schizophrenic. He'd also been a longtime drug addict. And he was both of these things during the period of time in question in the case, and that he had not been taking his medication for his schizophrenia during that period of time. He also admitted that he'd been hearing voices, he'd had hallucinations, and all of that was happening at the time that this alleged murder plot was being planned. So we had previously requested Brady material and Giglio material, and the government had said for over a year there isn't any. They had already concluded, although they didn't say this to us, but they just said, no, we don't have any Brady material, we don't have any Giglio material. But in their minds, they had concluded that all the information in Rosa's prior statements didn't need to be produced until they produced the Jencks material. And on top of that, the government knew from these interviews that Rosa had these mental health problems. They'd known this for well over a year, but they had not gone out and gotten any of his mental health records. And I think they did that because they knew that if they had gone out and obtained those, they would have had to produce them to the defense. So what I did was in preparation for my trial, I asked the judge, I wrote a detailed memo to the court explaining why I was entitled to get a subpoena for all of Mr. Rosa's prior medical records. And I didn't send that to the prosecution, I only sent it to the judge. And my argument was basically the government had made Mr. Rosa's mental health an issue in this case. And my client couldn't get a fair trial without having those records. And so the judge granted my request to subpoena these records, and I issued my subpoenas, and the more records that came in, the more I discovered existed. And it turned out, and in some cases, the facilities, because of medical privacy laws, did not want to produce them. So ultimately what happened was I sat down with the government and I said, look, you've made this an issue. And we agreed that Mr. Rosa would he would consent to disclosure of his records as long as we produced everything that we got to the government. Okay, so both sides had everything. But I had to do all the work, okay? And I issued subpoena after subpoena, made call after call. I contacted multiple hospitals, all the jails that he had been in. I got all the records. It was thousands of pages. And it turned out he'd been hospitalized several times for schizophrenia, including right around the time of the events in question. There were multiple incidents at the federal detention center where he was incarcerated. And these raised serious, serious questions about his credibility. And I would note that, the judge in the case, who's a very good judge, he gave us time to do the research and to do the investigation and get the information, but he wasn't outraged. he didn't discipline or criticize or scold the prosecutors for not producing this material earlier, for not gathering the material. To the judge, this was just normal. This was normal. So that's how this can unfold. I provide this example because I think it really illustrates well the danger of allowing the withholding prior statements of witnesses until after that person has testified or shortly before trial. If you can investigate the case, it helps the defendant to decide whether there might be a legal basis for moving to dismiss the case. It helps the defendant decide whether or not to plead guilty or proceed to trial. It helps the defense prepare for and conduct a trial, including cross-examining the prosecution witnesses and persuading the jury. For a year, the government maintained, for a year we went back and forth with the government. My client was willing to plead to a conspiracy to commit a robbery, even an armed robbery. The government said, and we said, how can you believe Rosa? We know this guy has problems. We know he's a drug addict. He's unreliable. Of course, we didn't even know a fraction of what was really going on. But the government maintained that they were absolutely confident that this was a murder plot. And the only basis for that was this one individual who had all of these severe problems. And they never disclosed that to us. They wanted us to plead guilty to a murder plan based on very, very compromised evidence. There are situations, to be fair, there are situations where witness security is an issue, national security might be an issue, privacy of individuals or third parties may be an issue, compromising an ongoing investigation. Those things, I think, can, in the right circumstances, warrant special consideration. But those, I think, are cases that can be dealt with on a case-by-case basis, and they shouldn't dictate the entire rule. Now, I want to talk about the case of U.S. Senator Ted Stevens. This was a very, very significant case in the United States. In 2008, Ted Stevens was serving his 7th term as a United States Senator from Alaska. And he was indicted that year on several counts of making false statements in his financial disclosure form to the Senate. And these, the alleged false statements had to do with expenses for home renovation services that he had received. So he received these home renovation services from a company owned by somebody named Bill Allen. And he reported these as expenses. The government claimed that he'd made some false statements in connection with these financial disclosures. Now, this indictment of Senator Stevens had its roots in a public corruption investigation that had been going on for several years in Alaska. Bill Allen was the key witness against Senator Stevens, and he'd been cooperating with the government for many years during this public corruption investigation, for about 2 years. And he was trying to avoid prosecution for his own criminal conduct. Now, the government knew that Senator Stevens was running for re-election in November of 2008. And so he was indicted a few months before that election. And he requested a speedy trial because he wanted to clear his name before the November election. And the prosecutor said, okay, we'll agree to that. But it turned out they were really, really unprepared to provide the Rule 16 discovery, and they were also very behind in their review of Brady material and Giglio material. And so keep in mind, Bill Allen and others had been cooperating in an investigation that had been going on for 2 years. So that meant there were pages and pages and pages of prior witness statements. And in order for the government to properly adhere to its obligations under Brady and Giglio, it has to know what's in those statements. Okay? It has to have reviewed them so that it knows whether there's favorable material evidence in there and also, potential impeachment material. But it turned out, we learned later, that the prosecutors had actually never conducted that review themselves, nor had they properly supervised anybody else to conduct that review of their files. They really hadn't, they had not reviewed their own notes of the witness interviews. And those notes, in fact, contained significant Brady information that was never disclosed to the defense. And, during the trial, the judge observed these deficiencies by the prosecution over and over again. And I should note, this was a very high-profile trial, okay? There was a very large prosecution team, and there was a very large team of defense lawyers. I think Senator Stevens had a team of 12 lawyers, some of the most experienced and well-respected defense lawyers in the country. That's not the case with most criminal defendants. Most people have one lawyer, maybe two lawyers, some court-appointed, some that they can barely afford. And so this is an unusual case because it involved such a prominent person. There were so many highly skilled lawyers involved. But some of the things that happened during trial include, a week before trial, the defense made a motion for Brady material, and the judge ordered the prosecution to provide reports of any witness interviews that contained Brady material. And so what did the government do? The prosecutors went through the witness interview reports, and they redacted anything that they considered to be not Brady material. So, what they produced was these redacted. This is a week before trial. Eventually the defense is entitled to get these prior witness statements, but the government wasn't even willing to produce these witness statements at that point. They said, oh, we're only obligated to produce the Brady material, so we're going to take out everything else. And then later, after the government had already started its examination, its direct examination of Bill Allen, its key witness, they came to the judge, the prosecutors came to the judge and said, oh, Judge, we accidentally redacted Brady material from one of the Allen witness reports. And so the judge said, okay, we're going to stop this witness's testimony, and he ordered disclosure of all unredacted interview reports for all of the prosecution witnesses. This is in the middle of trial. And so what that led to was discovery of more undisclosed Brady material. Now, 8 days before the November election, Senator Stevens was convicted. He lost the election by 2 percentage points. It was a very close election. And then after trial, now the judge had was very concerned about some of the things he had observed during trial about the conduct of the prosecution team. So a new team of prosecutors was actually assigned to this case, and that new team of prosecutors looked through the evidence, and they discovered additional exculpatory evidence that had been withheld from the defense. So, after the judge had ordered these prosecutors to produce exculpatory material, more than once, and there had been more than one production, after trial, after conviction, even more was discovered. So, in this case, the Department of Justice, recognizing that this was serious and very high profile, moved to set aside the verdict and dismiss the indictment. And the judge granted that motion, and the judge did something else which is very, very unusual. He appointed an attorney to investigate what had happened in this case. That attorney was a very well-known defense attorney in Washington, D.C., a former prosecutor, and he did a very thorough investigation with a team of attorneys. That investigation took over 2 years. It resulted in a report between 500 and 600 pages, and it documented systematic concealment of exculpatory evidence. And that evidence would have corroborated, it would have supported the defense, okay, and it also would have impeached key government witnesses, including the key witness, Bill Allen. Now, Senator Stevens, sadly, died in a plane crash in 2010 before the investigation was completed. Before his death, he had advocated for legislation that would prevent the kind of thing that happened in his case from happening to other defendants, especially defendants who did not have the resources that he had and who did not have such a high-profile case that would result in this kind of action by the government. But no legislation was ever passed. What happened was the Department of Justice issued guidance to all of the assistant U.S. attorneys working for the Department of Justice. And this guidance set out, the rules for the department's standards for criminal discovery. The department also conducted additional training on how to identify and how to disclose Brady material. But none of the prosecutors in the Stevens case were ever prosecuted, or none of them were disbarred. 2 of them, I think the judge may have briefly held them in contempt, but really the prosecutors in that case did not suffer serious professional consequences. Actually, before we get to this next case, I should add that the Department of Justice has testified before Congress on this case. They've maintained that the conduct in this case was the exception, that no new rules or legislation is required. In the view of the Department of Justice, the solution to the problems that happened in the Ted Stevens case is more training by the Department of Justice of its own prosecutors. And I think yesterday I talked about the Office of Professional Responsibility that is part of the Department of Justice. At the time that the Department of Justice was testifying before Congress about this case in 2012, this was 4 years after trial, the Office of Professional Responsibility still had not concluded its investigation of the prosecutors. And that's very typical. These OPR investigations which are investigations by the Department of Justice of its own prosecutors who are alleged to have engaged in misconduct, usually take a very, very long period of time. And in most cases, almost all of them, the Department of Justice does not ultimately release any information about the investigation or the details. It's very much like when there are internal investigations of police officers. There's real reluctance to publicly provide any information that might be damaging to one of the police officers, or in this case, to one of the prosecutors. We had a case in New York where one of the prosecutors was found by the court to have falsely testified during a trial, and that prosecutor was not disciplined. He was just transferred to another office and later came back to the same office. Also yesterday I mentioned the Department of Justice Discovery Blue Book. That was another action that the Department of Justice took in response to the Stevens case. It was a book that they wrote containing detailed policies and procedures related to evidence disclosure. And of course, many defense lawyers wanted to see what's in the Discovery Blue Book, because if we can see what standards the government sets for itself, we can, then determine whether or not we think the government has complied with those standards in any specific case, and then make a motion to the court saying, the government has this policy and they haven't followed this policy. The National Association of Criminal Defense Lawyers made a Freedom of Information Act request for this Discovery Blue Book. The Freedom of Information Act is a law in the United States that allows private parties to ask the government for certain information that's not generally made public. And usually it has to be produced unless there are compelling reasons for it to be withheld. And so my National Bar Association made a request for this book, and it was denied. So the organization filed a lawsuit. The district court decided the Blue Book did not have to be disclosed. And then on appeal, the Court of Appeal said, well, we're going to disclose a little bit of it. And so the little bit that was disclosed was kind of the general statements about the Department of Justice policies, which actually are broader than the legal obligations that the prosecutor has. So the Department of Justice holds itself to a higher standard than the actual law does, at least in their policy statements, but they don't necessarily follow those in practice. After the Stevens case report was made public, in 2013, another case was decided in the Ninth Circuit. That's the Court of Appeals in California and the West Coast of the United States. So this court in United States versus Olson reversed a conviction where the prosecution had failed to disclose a key document that had raised serious doubts about the integrity and credibility of one of the key government witnesses. One judge on this court was so disturbed by the court's unwillingness to reconsider the case that he wrote a dissent, and he was critical of what he called an epidemic of Brady violations. And he said, and I think this quote is important, he said that the court's failure to reconsider its decision upholding the conviction he said, it effectively announces that the prosecution need not produce exculpatory or impeaching evidence so long as it's possible the defendant would have been convicted anyway. This will send a clear signal to prosecutors that when a case is close, it's best to hide evidence helpful to the defense, as there will be a fair chance reviewing courts will look the other way, as happened here. What this judge is saying is the materiality standard that the courts use when they're reviewing cases after a conviction, where they're looking to see if the evidence that wasn't disclosed would have led to a different outcome, is very problematic, and it encourages prosecutors to take a chance that, we won't disclose, maybe it'll get discovered, maybe not, and even if it gets discovered, the courts probably won't do anything, and there's not going to be any harm to me personally if I fail to do so. And some judges recognize that that's a real problem, but we haven't seen in the United States any concrete changes in our laws requiring more complete disclosure of evidence, both generally and specifically related to favorable evidence favorable to the accused, as well as evidence that might impeach the government witnesses, as well as prior statements of witnesses. And you can see from the case example I gave how problematic it can be for a defendant to have to decide what is really that person's most important decision. Do I plead guilty or do I go to trial, without really knowing what the evidence looks like, and particularly for somebody who's not guilty. Okay, somebody who's not guilty really has no idea what the evidence looks like, and it's a terrifying situation to be in, and it's a really unfair situation for somebody to be in. So, I bring up the Ted Stevens case because I think it's so significant that this case has received so much attention in the United States. It's been written about in newspapers over 2 years. We're spent investigating the case. The United States Congress has held hearings on it, but it really didn't result in any meaningful change in practices and procedures in the United States concerning evidence disclosure, except that now prosecutors do get more training in this. They do get more training. It's now required that they get annual training. This is according to the Department of Justice's own actions. They've imposed a requirement that prosecutors must get annual training in evidence disclosure. So that's a positive step, but that really still keeps the fundamental problem intact, and that is, we still have a system where the prosecutors really have tremendous power to decide what evidence to disclose. And even the most diligent lawyers, the lawyers in Ted Stevens' case, diligently requested production of the material that they are entitled to. But the government, in this case, and it's not even clear in the Stevens case that this was deliberate. It was clearly negligent. They knew what they knew they were doing is they knew that they were not looking at their case file to find out whether or not there was exculpatory evidence. They knew at a minimum that they were doing that. It turned out afterwards that they had done more than that. They had actually hidden some exculpatory evidence that really likely would have changed the outcome of the case. But not all cases involve deliberate misconduct like that. I think so many of them are just either the government has so much material, they haven't reviewed it, they don't have the time to review it to determine whether or not there's favorable information. You know, and you have to ask yourself, why do we have a system where we're asking the government to go through its file and find the evidence that's favorable, as opposed to just turning it all over to the defense? Because the defense, after all, is the side that is in the best position to do that review. So I think, you know, the fact that we haven't really seen meaningful change after the Stevens case indicates to me that it's very, very difficult to change your practices once they've been in place for a long time. It's hard to change your history. It's hard to change the way you've been doing things for a long period of time, especially when you have long-standing institutions that have become very fixed on their way of doing things. In this case, in the Stevens case, the Attorney General at the time recognized that, you know, there were problems in that case, but still the department as a whole was unwilling to change its practices in any serious way. They aggressively resisted any change in the law. So I really want to say that I have great respect for the process that Taiwan and this group of people who organized this conference and who are attending this conference are undertaking, because I think it is really important to look at experiences from other countries. I think it's extremely valuable to learn from those. I think there are aspects of the system in the United States that are very, very good, but there are aspects that can be improved. And so, you know, I give you great credit for the process that you're undergoing, and I really look forward to continuing the discussion with you, both, you know, this afternoon and also as Taiwan begins to implement change. So thank you so much for your attention, and I really congratulate you on the efforts that you're making as a country.